With this, ladies and gentlemen, I request Mr. Venkatesh to make his presentation.
May I request the organizer to switch on to the PowerPoint board?
Yes, thank you so much. Honorable Chief Justice Retired Justice Shah, Honorable ex-Chief Information Commissioner Mr. Tiwari, Mr. Lohani, serving and former Chief Information Commissioners and Information Commissioners who are seated in this hall, members of various governments and representatives of civil society who are sitting way there at the back. I am a bit troubled today to make this presentation for two reasons. The first reason, of course, is we have such legal luminaries on the dais, and there are some eminent jurists and law academics sitting in the audience like Professor Madhav Menon and Professor Acharya. I, not being a lawyer, talking about a subject that has to be closely with law, one has to be very careful. So if I make any mistakes, I am depending upon them to correct it. The second reason why I'm a little worried is because of the times that we find ourselves in. 3 years ago, I made a presentation on the right to privacy, its history and evolution, without any hesitation. Because matters were very clear, there was no confusion in the law. Today, thanks to what happened before the Honorable Supreme Court of India in August, I no longer know whether we have a fundamental right to privacy. It's not my doubt, it's a doubt raised by and raised before the highest court of this country. And actually the doubt has been accepted as an element that needs clarification. So that's the context in which I'm making this presentation, so kindly bear with me. Now, most of what I was planning to say has already been very adequately covered by Justice Shah in his presentation. I'm only going to make a little more detail available within the limited amount of time that I have in front of you without boring you too much. It's very interesting that even before there was a serious discussion about the right to information during our freedom movement. The discussion was, when the discussion took place on fundamental rights that citizens should have in independent India, there was no mention of right to information. Amongst a series of rights, there was a mention of the right to privacy. And this is first voiced in 1895 in the Constitution of India Bill, which we are told was prepared under the blessings of Bhagavad Tilak and Anne Besant. Then in 1925, the Commonwealth of India Bill that was drawn up by Sir Tej Bahadur Sapru with eminent members like Gandhiji, Sarojini Naidu and Bipin Chandra Pal, they recognized that every person should have the fundamental right to liberty of person, security of dwelling and property. So it was a very comprehensive idea that was perhaps borrowed from Anglo-Saxon understanding of what an individual should be entitled to in terms of his own or her own autonomy. The Nehru Swaraj report 3 years later recognized the same principle. Netaji Subhash Chandra Bose and Motilal Nehru were some of the eminent members of this panel. Things change when the Constituent Assembly starts debating what kinds of fundamental rights guarantees should be incorporated in the Constitution. 1946 onwards, the process of expert members of the Constituent Assembly drawing up notes for discussion in the Advisory Committee on Fundamental Rights and the Subcommittee on Fundamental Rights, they are drawn up and put for discussion. I will not go into the details. I'll leave this presentation with you. You can always take a look at it. Eminent members of the Constituent Assembly like Mr. K.T. Shah, K.M. Munshi, Harnam Singh, and of course, Baba Saheb Ambedkar strongly vouched for the incorporation of a protection for citizens' right to privacy against the all-pervasive powers of the state. And finally, the draft that was approved by the Fundamental Rights Subcommittee in March 1947 recognized 2 layers of rights of privacy. As far as inviolability of the home was concerned, inviolability of the home by the state, that was a right that would be available to all persons. But the right to secrecy of correspondence of a person would be available to citizens. So this was the compromise formula that they initially put in the draft. But the final report of the Fundamental Rights Subcommittee recognized, of course, the rights of people and all citizens, again, two-layered, but this incorporated the more comprehensive formulation that was developed by Dr. Babasaheb Ambedkar. Then comes the problem. Three eminent members of the Constituent Assembly, two of whom were eminent jurists, Aladi Krishnaswamy Iyer and Sir B. N. Rao, was the constitutional advisor to the Constituent Assembly. They said that we cannot incorporate a right to privacy in the Constitution for reasons of maintenance of law and order. They said that right to privacy, if it were to be incorporated in the Constitution, it would impede law enforcement and criminal prosecution of conspirators. Police should have the right to enter into these premises and apprehend persons suspected of having committed a crime or who are likely to commit a crime. An international perspective was also taken. They said the United States Constitution does not guarantee secrecy of correspondence and therefore they cannot have that in India. So finally, the advisory committee dropped both the draft articles on the right to privacy, and eventually the constitution came to be adopted and enforced without any explicit recognition of the right to privacy. So to that extent, the plea taken by the Honorable Attorney General of India before the Supreme Court in August, to that limited extent, is correct. I will not go into the details because some of these cases have already been talked about by Justice Shah. For the first time in Khadak Singh, a full bench of the Constitution bench of the Supreme Court did not recognize the right to privacy explicitly, but it said that privacy can come within the ambit of the concept of ordered liberty under Article 21, which is a guaranteed fundamental right. But then, 1970s onwards, in a catena of judgments, the Supreme Court has made it clear that the right to protection is available as a fundamental rights guarantee, not in an absolute manner, but in a substantial manner for various things, like personal intimacies of home, family, marriage, motherhood, procreation, child rearing, etc. And these were all necessary, according to the court, for the purpose of protecting individual autonomy. R. Rajagopal recognizes the principle of an individual's right to be left alone. Unless he or she consents, information about his or her life cannot be published by the media unless some of that information is available in public records. And of course, as Justice Shah pointed out, the degree of protection of privacy for public servants is of a lesser order, slightly lesser order, than that which is available to private citizens. Then there are several other cases like Mr. X versus Hospital Z, Sharda versus Dharupal, in the context of privacy of personal health records of individuals. We'll not go into the details, we can take that up during the question and answer session. But one very interesting distinction was drawn by the Honorable Supreme Court in 2004 in this District Registrar and Collector Hyderabad versus Canara Bank, where they said that the protection of right to privacy under Article 21 is available to persons and not places, which is a concept that's quite distinct from the kinds of protection that is available, that are available in other advanced jurisdictions around the world. And then the Nas Foundation case decided by the Delhi High Court, of which Justice Shah had a role in this judgment, where they said that right to privacy covers the right of every person to make choices about one's sexuality and build relationships without harming others. Quite unfortunately, this judgment was set aside by the Honorable Supreme Court in Suresh Kumar Kaushal and Anadol versus Nas Foundation. And this is something that's very popularly known as the Section 377 case of the Indian Penal Code, which criminalizes same-sex relationships and same-sex interactions. There are some other cases in the and it's necessary to look at some of these because of the thesis that I'm going to present before you after I complete this run of list of cases. In PUCL versus Union of India in 1996, the Supreme Court said unauthorized telephone tapping violates the right to privacy, and this position was upheld and directions were laid down as to how the government would go about tapping people's telephones for the purpose of law enforcement in the state of Maharashtra versus Bharat Shantilal Shah in 2008. In 2010, the Honorable Supreme Court said polygraph and brain mapping tests, which the police routinely undertake on suspects of crime or those who are accused of crime, that this would also be a violation of the right to privacy. In Ram Jethmalani and others versus Union of India, popularly known as the Black Money case, the Honorable Supreme Court said in 2011 that revealing bank account details of individuals without establishing prima facie grounds to accuse them of wrongdoing, that would also violate the right to privacy. This case is still going on, as you are aware. So what is the traditional understanding of the right to privacy? It's a common law right. It's primarily a negative obligation of the state not to interfere in an individual's personal matters, his or her thoughts, correspondence, telephone conversations, family, home, right to make choices about a variety of matters. And of course, it was linked to the right to liberty and property, not to be encumbered without legitimate reason, which we will see a little later. There are several laws passed in India that also recognize the concept of privacy. The Indian Evidence Act of 1872 recognizes that information shared between spouses is to be confidential unless it is required for law enforcement purposes. The Income Tax Act 1961, initially after 1964, recognized complete confidentiality of income tax returns, but in 1964 the law was amended to allow access to income tax returns or SSCs in public interest. Nevertheless, the concept of confidentiality of and privacy of income tax returns, particularly of individual SSCs, is still there. The Banking Regulation Act, Bankers Book Evidence Act of 1891, and the subsequent circulars of the Reserve Bank of India make it very clear that customer-related information that banks hold are covered by the concept of confidentiality, and violation of that confidentiality would be a violation of their right to privacy. The same year as the Right to Information Act came into existence, another law was brought into force, the Credit Information Companies Regulation Act, and this law requires credit-related information about individuals to be kept confidential. Similarly, the Information Technology Act of 2000 and the subsequent information technology rules recognize the concept of electronic privacy. For a much more comprehensive list of such laws which have implications on the right to privacy, I would urge you all to look at the report of the group of experts on privacy chaired by Justice A.P. Shah in 2012. Apart from looking at all the background material, this group of experts drew up a comprehensive framework for a right to privacy law in India that incorporated the element of data protection, which has still not been legislated upon in India. Now, as Justice Shah pointed out, right to information is not only implicit in Article 19(1)(a), it's also implicit in Article 21, Article 14. So what's interesting is we also have a situation where Article 21, in some judgments, the people's right to know what's happening in government is recognized, and within the same article also is covered people's right to privacy. And therefore, this conflict between RTI and right to privacy has to be resolved on the basis of specifics of each case. And now here I put forth my thesis. Section 8(1)(j) of the Right to Information Act, you are all aware, I don't need to go into the formulation. You have used this, you have upheld claims of Section 8(1)(j) or you have rejected claims in the course of your designated duties under the Right to Information Act. I believe that Section 8(1)(j) gives effect to the deemed fundamental right to privacy guaranteed under Article 21 of the Constitution. Although at the moment it is just a statutory limitation on people's right to information. Now let's look at the practical side of it. I have some data from the annual reports of the Central Information Commission, where amongst a few information commissions across the country, exemption-wise breakup of the number of times an RTI application is rejected is provided. So the experience between 2006 and 2013 is between 22 to 34% of the RTI applications every year are rejected under Section 8(1)(j). So this is the single most frequently invoked of exemptions as far as RTI Act is concerned for rejecting RTI applicants' request for information. Now, are similar trends noticeable in other states? We don't know, because many of the state information commissions do not capture this kind of data breakup. So technically speaking, the right to information, the right to privacy has often trumped the right to information since 2005 when the RTI Act became operational. Now, the fundamental right to privacy was unsettled in August 2015 in the case that is famously known as the Aadhaar case, where the constitutional validity of the actions undertaken by the Government of India to enroll people with a biometric and demographic identity known as Aadhaar, supplying them identification numbers and in some cases cards, The constitutionality of all these actions were challenged in the Justice Case Puttaswamy matter. And in August, the Attorney General of India argued on the basis of a 1954 case and then the Thalassi case that larger benches of the Supreme Court have said that there is no right to privacy, therefore smaller benches, like benches of lesser strength, cannot sidestep that precedent that has already been set in and cannot declare the right to information as the right to privacy as a fundamental right. Now what does this, and of course, the Honorable Supreme Court said, yes, the Attorney General is making a point, so let us once and for all settle this matter, and has referred the matter to a constitution bench. This constitution bench has not been constituted. Yesterday, it was a 5-member constitution bench that only looked at the validity of Aadhaar and the scope of Aadhaar. That constitution bench is not looking at the constitutionality of the right to privacy. Now, a big question which will take a lot more time, and I don't want to go into that unless there are questions raised later on. My understanding is there are several judgments of the Honorable Supreme Court, not only in relation to right to privacy, but also how Part 3 of the Constitution must be interpreted. So my humble submission is, deciding upon the constitutionality of the right to privacy will require at least a 13-member bench. But I am subject to correction. There are other legal luminaries here who may take a different view. Now what does this lead to? Now this is the expansion of my thesis before you. The statement of objects and reasons attached to the Right to Information Bill tabled in Parliament in December 2004 said, amongst other things, that this bill is being brought to give effect to people's right to know under Article 19 of the Constitution. Now that's clear. This is not something that I have created or I have just cooked up. This is written in a bill that was tabled in Parliament, so it's in the public domain. So what's the implication of this paragraph of the statement of objects and reasons? We need to look at it in the context of Article 13(2) of the Constitution, which very clearly says, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. So Parliament technically cannot make any law that abridges fundamental rights guaranteed under Part 3 of the Constitution. Now let's look at Article 19(2), which explains the restrictions that are reasonably imposable on the right to freedom of speech and expression, and by logical extension on the right to information, which is a deemed part of that fundamental right. So 19(2) says, reasonable restrictions may be imposed in the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, public decency or public morality, or in relation to contempt of court, defamation or incitement to an offence. So if we look at these reasonable restrictions, the only connection with the right to privacy is that of defamation, as far as I can understand. So the constitutional basis for the right to privacy has all but disappeared and is awaiting judicial pronouncement. And the bench itself has not been constituted. So my humble submission to you, it's not a submission, it's a question for all of us to ponder. So is Section 8(1)(j) of the RTI Act, by and large, an unreasonable restriction on citizens' right to information, except in relation to information whose disclosure may lead to defamation of an individual? I am not making any authoritative pronouncement on that. I am nobody to do that. I am just throwing this question across to you because this seems to be the implication of the Honorable Supreme Court of India accepting that there is lack of clarity on the status of the fundamental right to privacy. Now, what does this lead to? If we accept this thesis, it throws a whole range of judgments of the Honorable Supreme Court and various high courts into question. Now, Girish Ramchandra Deshpande, decided by the Honorable Supreme Court of India in 2013, is something that is extremely popular when it comes to information requests relating to the official duties of public servants. Now here, the Honorable Supreme Court of India said income tax returns, immovable property statements, show cause notices, charge sheet and service records of an employee, these are all personal information. They have no relationship, unless they have a relationship to any public activity or interest, they cannot be disclosed because it will be a violation of privacy. So what happens to the validity of this judgment is a question. Second, in Central Board of Secondary Education, famously known as the answer scripts case, the Supreme Court said examinee who is an RTI applicant may see his own answer scripts but cannot see the validated answer scripts of other candidates because that will violate their right to privacy. What happens to this judgment? Then, in another judgment, it was said by the Honorable Supreme Court of India, this is the famous Talpadam case, The matter was whether cooperative societies in Kerala, as declared by the government that they are public authority, that declaration was struck down. And in that context, the Supreme Court discussed Article 21 and said that an information which has been sought for, if it relates to personal information, disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, Register of Cooperative Societies, even if he has got that information, is not bound to furnish the same to an applicant. So if the constitutional basis of the right to privacy goes away, then what happens to this protection is the next question. There are many other judgments. In the famous case that Justice Shah talked about, and he was also part of the full bench that decided this matter, where the Chief Justice was declared to be a public authority under the RTI, but they said that judges' assets declarations may attract Section 81J of the RTI Act, and the constitutional issues that were framed for determination by the Constitution bench, which has not been constituted till date. The third question, whether the information sought by the RTI applicant is exempt under Section 81J of the Right to Information Act, how is this going to be answered is another question. Now we have a very interesting instance where the Madras High Court in 2013 claimed the protection of privacy to its institutional functioning. For the first time in India, Article 21 was interpreted in a manner that it would not only provide protection of an individual's privacy, but also institutional privacy. So what would happen to this judgment is the next question. In the Naresh Trehan case, which was an outcome of a challenge to the decision of the Central Information Commission about disclosure of the income tax returns of an individual, it was held that unless there is public interest, this information will not be disclosed. But the other hospitals' income tax returns, they could be disclosed. So what happens to that decision is another question. Similarly, Delhi High Court in the Katina of judgments has talked about the right to privacy and protection available to individuals on a range of issues. Copy of caste certificates, information about third parties, and a variety of things which are kept confidential, passport details, copy of birth certificates. These were all protected by 81J, which was the legal, which was legally connected, umbilically connected to the Article 21, which guarantees right to privacy. What happens to these judgments is the next question. However, there is a way out, and there are a couple of ways out to protect the right to privacy. As Justice Shah pointed out, several international declarations and covenants recognize the right to privacy, and India is party to these covenants. So Article 12 of the Universal Declaration of Human Rights, which of course is not a binding treaty, which recognizes the right to privacy. Article 17 of the International Covenant on Civil and Political Rights is a binding convention. India has acceded to this convention and is duty bound to ensure that various rights recognized under this covenant, including the right to privacy, are made available to the citizens under its jurisdiction and the people under its jurisdiction. Protection of Human Rights Act 1993 defines human rights as all rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution, or embodied in the international covenants and enforceable by courts in India, so that would include the ICCPR, and therefore it appears that at least even though there is a doubt on the about the status of the right to privacy as a fundamental right, there is enough clarity about the fact that the right to privacy is a basic human right and it is enforceable in the courts of India. Now my last point here, Justice Shah alluded to this as well. I think this is perhaps the only judgment across the country where the concept of personal data protection is recognized as an aspect of right to privacy. This is say a famous Supreme Court judge's asset case. I haven't seen any other judgment that talks about data protection as an element of right to privacy, but I could be wrong. Perhaps some of you may have seen other judgments as well. So what does this require? My humble submission is this, that there is a writ quite popular in many European countries and Latin American countries called habeas data. Now this is something that organically grew out of a case in 1983 called the population census case in Germany, which is something very similar to the Aadhaar controversy that is going on here. So the Constitutional Court of Germany actually said that you cannot convert people into databases, and therefore citizens must have individual autonomy, their autonomy on their personal information, and out of that flow all the other data protection principles and data protection laws in European Union today. So we have in many constitutions in Europe, in the Philippines, in Asia, and in several Latin American countries, the writ of habeas data, which is nothing but the right of an individual to move a court to seek enforcement of the right of access to personal information, either in his or her own case, or if he or she is not available, then that right can be exercised by the family, and the court can be moved to issue a writ of habeas data to get the information from public agencies and private agencies made that accessible. It's similar to habeas corpus, where you ask about the individual who's been taken away by the law enforcement agencies. Here you're asking about the data that is under the control of public authorities or private agencies, which is not easily accessible. Through courts, you try and get access to this data. So I believe that the Indian Constitution and Article 32, which gives the powers of issuing writs to the Honorable Supreme Court, and Article 226, which gives the power of issuing writs to various high courts across the country. These are inclusive provisions, and therefore what we require is an interesting test case to be brought in to recognize the existence of habeas data within these articles. So ladies and gentlemen, this is where I'm going to end my presentation and say that what we need to do today is seriously engage with this controversial situation that has occurred, where the government of India has said we are not sure whether there is a right to fundamental right to privacy. Now this not only affects the rights and entitlements of various citizens, it also affects all your work. So it would be very important for most of us to become interveners in this case and have our say before the Honorable Supreme Court, so that it can make its decision, it can arrive at a finding in a considered manner, and I think that's something that we need to be taking a call on, because we cannot expect ourselves to be a civilized society and say that no, there is no fundamental right to privacy for citizens in this country. Thank you.